Hello, folks. Welcome back to World War II TV and the first of a double bill today. We're looking at Japanese paratroopers later on today with James Fenelon. Anyway, we had a good introduction to Australia's role in the trials of Japanese criminals with Adam Wakeling at the beginning of this series. Today, David Gormley-O'Brien joins us to offer a deeper dive into the set of trials on one of the East Indonesian Maluku Islands. I'll bring him in now. It's evening in Australia. It's morning here for me in Normandy. Good evening, David. How are you today?
Good evening, Paul and everyone. Yeah, very well, thank you.
So, as a first-time guest, I like to ask people kind of how they define yourself, because you talk about yourself on your website as being a writer, but obviously you've done this military research. Do you have a label you like to give yourself?
Yeah, look, I am an independent researcher now. I've had a university teaching career for 20 years in the area of late Roman antiquity, and I've moved into 20th century Australian social history, and especially covering the aftermath of war and the impact of war on the Australian society.
Well, brilliant stuff. That's exactly what we wanted. A nice, articulate response there. So I'll bring up your slides. And folks, if you've got kind of big questions for David about perhaps how Australia sees itself with regards to the war crimes trials, we'll do those at the end. But of course, if you have them about particular things that are on screen, we'll deal with them as we go along. And I can hand it over to David, take us through this, and we'll sit back and do a bit of learning. So over to you, sir.
Thank you. Thanks, Paul. Between 29th of November 1945 and the 28th of February 1946, on the remote island of Morotai, the Australian military convened some of its first war crimes in the Pacific. In this 3-month period, the Morotai court prosecuted 129 Japanese officers and enlisted men accused in 25 trials, accused of committing war crimes against Australian crashed airmen and prisoners of war in the surrounding islands, and at the time confronting unique legal, political and logistical challenges. In this first slide, you'll see a gentleman, as an accused, Captain Iwasa, being searched just before he enters the courtroom at Morotai. Captain Iwasa is one of the main protagonists in today's presentation. So you'll see him coming up later. Background to Morotai. Morotai is a small island lying of the Halmahera group in the Netherlands East Indies, nowadays Indonesia, lying just above the equator between Western Papua and the Philippines. And it's cloaked in dense rainforests and mountains. The density of its rainforests is evinced with this the gentleman on the right, who is Private Teruo Nakamura, the last holdout of the Second World War. The Indonesian army located him in December 1974. 30 years after he had gone missing. And he just simply didn't know that the war is over. So that's Nakamura. Morotai itself proved, even though many people may not have heard of Morotai, but it proved pivotal in the war. The Japanese seized it early in 1942 to build an air base to cover its right flank during its attack on New Guinea. But the swamp and jungle terrain proved too much for their engineers, and they abandoned the project and moved further south to build their base. And they left just a small garrison in Morotai. Douglas MacArthur, however, saw Morotai's value later on in the war as a springboard for the Philippines invasion. And on the 9th of September 1944, the US 31st Division landed and secured the island within a day, suffering only a single casualty from a falling tree. And when I say secured the island, I'm actually referring to that little peninsula that's jutting on the southwest,
right,
very close to the 0 kilometers. That peninsula was basically the American base for the invasion of the Philippines, for its advanced headquarters. When Manila fell, very quickly, the American and Australian engineers, using bulldozers and dynamite and all that, crushed the coral and built 2 large airstrips, and also built naval facilities. So that little peninsula down the bottom, down south, became the forward base for the invasion of the Philippines. When Manila fell in March 1945, MacArthur moved his headquarters there, his base there, and he gave that peninsula to the Australians, to the Australian First Corps, for its operations Oboe, the campaigns in Borneo during from May to July 1945. A little bit later on the 9th of September 1945, Lieutenant General Tashima surrendered to the 2nd Imperial Japanese Army to General Blamey on Morotai, and this was viewed by thousands of Australians, by Australian troops who had been moved back from Borneo to Morotai as a staging area again for their trip back home, so for their repatriation. The only thing is there were no ships to take them. So in effect, the Australian troops were waiting impatiently for months on end to be returned home. And look, when you think of a Pacific island, you think it's all lovely and all that, nice place to visit for a holiday, but to be marooned on the island where the food is terrible, the humidity and the great heat, the rains every night, and they're all intense. So it's raining every night, and in the morning there's an inch or two of water. And as I mentioned, the terrible food, they're living on bully beef and all that type of thing for most of the time. And they just wanted to get home. And they were really actually concerned about getting jobs, because the impression was that the other troops around in other theatres had been already returning and taking all the jobs. So it was a very difficult time for them. However, at the same time, the ships that were available were bringing prisoners of war home. And so there was a sense that, at least those ships are doing that. But in December, I think it was December the 13th, it got to a head. We had over 4,000 Australian troops on the island in that little peninsula area. So it was actually quite densely packed. And they did a protest march. We want ships, not assurances. The commanding officers just had no ideas when ships would bring them home. So there was a huge issue there. Also, around this time, you had those from the 7th and 9th Divisions wanting to be repatriated, demobbed and repatriated. You had the formation of a new brigade called the 34th Brigade, which was for the British Commonwealth Occupation Forces in Japan. So this is all happening on Morotai at the same time. So Beikoff, which Australia was very keen to not merely participate, but to actually lead, was forming on the island at this time. And so you had congregating on the island troops from not only from Borneo, but also from Bougainville and Wewak and all that in New Guinea. However, they too, the Beikoff troops, the whole brigade, so around 4,000 or 3,000 troops for Japan, were also waiting. The Australian government was in protracted negotiations with the American government. The Americans did not want the British, and hence the Australians, in Japan for the occupation. They didn't want to share it. They wanted to have a military government over the whole island, over the 4 islands of Japan, and the Australians basically represented the other Commonwealth countries in negotiating an opportunity for the British to have a foothold on Japan during the occupation. And it wouldn't be until February 1946 that they would be able to embark and settle in the Hiroshima Prefecture. But that's on the negative side of things, where the troops are waiting both to go to Japan and back home to Australia. But at the same time, those troops gave the opportunity for the Australian forward headquarters, to actually run a prisoner of war compound, and also to accompany investigators to the surrounding islands as they gathered in suspects for war crimes. So they provide the infrastructure as well as the security for the Australian war crimes trials at Morotai. After Japan's surrender, Australia moved quickly to assert its sovereignty by conducting its own war crime trials against Japanese suspects. Now, that's a very interesting phenomenon. New Zealand, for example, next to Australia, did not. They were quite happy for the war crimes against their against their troops, to be conducted by the British. The Australians insisted on doing it themselves. Preparations for these war crimes had begun much earlier. In June 1943, the Australian government, alarmed by reports emanating from the field in New Guinea of atrocities being committed by Japanese troops, appointed Sir William Webb to investigate. And his inquiry, which is available now on the web, reading it's just horrific, the scale and the severity of these atrocities committed against Australian troops, against natives in New Guinea. The findings for Webb's first report were not revealed to the Australian public until the end of the war, partly to protect the families of the identities of those who had suffered, but also, and this is an Australian phenomenon, trying to avoid reprisals by the Japanese against their POWs. Australia did have 22,000 POWs under Japan in Japanese hands, and we were very conscious not to. It's futile, really, but to get reprisals. As the Allies advanced through the Southwest Pacific, many more atrocities were uncovered, and MacArthur and General Blamey, who was CNC of the Australian Military Forces, authorised Webb to visit crime scenes and interrogate suspects and witnesses. His reports, subsequent reports, could not be used directly for the war crimes trials, but they gave the investigators at the end of the war the information they required to the places and what crimes were committed, so they can do the proper investigations for the trials. The Allies established a 3-tiered system, which I think most of you will know, for prosecuting Axis war crimes. Class A covered senior political and military leaders accused of beginning and waging aggressive war, to be tried in international tribunals in Nuremberg and Tokyo. Class B addressed conventional war crimes against combatants. Class C dealt with crimes against humanity pertaining to civilians. Trials in Class B and C were conducted by individual Allied powers under their own military courts. At first, it was intended that these trials be held at the scenes of the crime by whichever allied nation had the greatest number of victims. So we're talking here British, Dutch, Australian, and of course US as the main ones involved in this theatre. However, this proved impractical. Instead, Australia, Britain, the United States, and the Netherlands informally divided the Pacific theatre, each nation prosecuting crimes in its zones it controlled or where it had overseen the Japanese surrender. The novelty of exercising extraterritorial jurisdiction over persons not otherwise subject to Australian law was deemed to require fresh legislation. And on the 4th of October 1945, a hastily drafted war crimes bill passed both houses of Parliament, of Australian Parliament, in a single day and received royal assent 1 week later. The War Crimes Act 1945 and its subsidiary regulations empowered the Commonwealth to try persons accused of war crimes committed anywhere, within or beyond Australia, against anyone who at any time been resident in Australia or against any British subject or citizen of an allied power. It also authorised the courts to sit at any place within or beyond Australia.
A quick question for you, David. Do you think that was... It seems very, very sensible to me that the Australians are changing their legal structure essentially before they begin the trials, because as we've been finding out with this series, what seems to be happening is there's this urgency about bringing people to justice. So they start arranging things and then they have to amend the legal structure as they go along, which, as we've found out, and we will find out in our next series, caused problems along the way of just the complications of it. So Australia, as you said, you put it all this through the House on the single day and got that infrastructure in place in advance. Seems quite wise to me.
Yeah, look, I think it was a noble attempt. I think in the trials, both prosecution and defence agreed that it was hastily written.
Yeah.
So there was a sense of being uncomfortable with its content. But the British had the predecessor to the War Crimes Act was the Royal Warrant, which the British came up with, which is a much smaller document, I have to admit, which came out in June 1945 in order to prosecute the Nazi crimes. But I think my understanding is that the War Crimes Act is a bit more comprehensive, but there's still a sense of it being rushed, and there was a sense of embarrassment by the legal people who had to deal with it on the spot in the various locations.
And also that fact, we talked about it with Adam on the first show that I mentioned at the top of the show, is that there was some public outcry about this in Australia, New Zealand and beyond because of the very savage nature of some of the Japanese war crimes, because it is beheadings and torture. Whereas with the Nazis, you end up with that kind of mid-management level of atrocities, the people ordering trains and ordering production of things where it doesn't have that same kind of resonance with the public of someone, setting up an account system in order to persecute people in the Holocaust. Sounds somehow less emotional than someone actually, as we'll find out, whipping out a sword and beheading someone in the field. It instills more of a primitive reaction. So it's interesting, again, the different countries looking at it from a different legal structure, and also looking at the particular type of cases that are against their people. That, as we talked about Norway yesterday, every country in the world had a different sort of set of crimes committed by a different set of people for different reasons that had to be then treated differently. But yeah, fascinating stuff. And I'll hand it back to you.
Yeah, you're perfectly right. Look, the Japanese crimes against Australian POWs was a very raw wound in Australia. And it's quite interesting to know that the Australians wanted their retribution more than, I would have to say, more than any other allied nation. As I'll say later on, Australia kept the prisoners of war war criminals, the Japanese war criminals, the imprisoned ones, longer than any other nation, with the exception of China and the USSR.
Yeah.
So
tells you something.
Australia were very adamant that these people had to be punished. Australia was really scared because for the first time in it's only a young country, but it felt the threat of invasion, and it wanted to make sure that Japan would never again, to use an Australian colloquialism, will never again arc up.
Yeah. Brilliant stuff. Thank you.
In the early post-war period, there are 6 Australian military courts trying Class B war crimes from the War Crimes Act. Labuan in British Borneo, Ambon, Wewak, Rabaul, Darwin, and Morotai. Later on, there'll be war crime trials in Singapore, Hong Kong, and Manus Island. Morotai was the first Australian military trials under the War Crimes Act, which would set a template for the later trials. We're going to look at the first set of trials here. They have to do with the execution of Australian airmen down during sorties over enemy territory in the islands around Morotai in the last year of the war. And I have here a photo of the 80th Squadron, 1st Tactical Air Force, which were based in Morotai. Those crosses, you'll see red crosses on them. The original photo just had black crosses, but I've just gone over. I've just written over with red, so it's easier to see. Those 4 men, 3 of them, Hahn, King, and Walters, were they were out on a sortie, flying in their Kitty Hawks, and they got lost, and they inadvertently, mistakenly landed in a Japanese airfield in the Talaud Islands, were captured, and subsequently they were murdered. The 4th person, Parry, was shot down, and there was someone observed him being shot down and going into the sea. Anyway, the first Morotai trials looked at that war crime of the 3 men, Hahn, King, and Walters, being killed. The Talaud murders. Very interesting story. In the top right, there are 3 Malay young men. The middle one, his name is Theophilus Jawera. He had seen what had happened. What had happened on the island of, at Bayo in the Talaud Islands, the Japanese regiment were celebrating the reception of their colours, of their flags from the emperor. And the culmination of that ceremony of celebration was to be the execution of the 3 Australians plus an American as a culmination. And what they did, they went into their 4 companies in a clearing in the bush. In the front of each of the companies, a large cross was placed. The 3 Australian airmen and the US airmen were tied, one to each cross. They were blindfolded. The company commanders, the Japanese company commanders, called out an enlisted man, or sometimes 2, to stand in front of the victims and to bayonet on the command to lunge bayonet. These were bayoneted into the heart, and they died suddenly, and the bayonets were withdrawn, and then the men were buried. And the soldiers then marched off behind their regimental flags. 9 trials investigated these Talaud murders, trying 16 accused war criminals, either individually or in 2s or 3s. We're going to look at one trial, and this is the gentleman, Captain Iwasa. So if I go into the previous slide again. So Iwasa is on the ship being transported to Morotai from the Talaud Islands. He is the second on the right. So the first military court, convened under the War Crimes Act, opened on Morotai on the 29th of November 1945. It was conducted in a simple hut with a corrugated iron roof beside a Japanese POW compound. 2 Australian flags, as you can see, flanked a portrait of King George VI. The court, 100 Australian servicemen on a ballot were able to attend. And the accused was Takeo Iwasa, a junior officer of the 211th Regiment, charged with murdering one of the Australian airmen. The War Crimes Act established military courts modelled on general courts-martial of the British system. They remained chiefly military affairs, in contrast with the international tribunals of civilian judges at Nuremberg and Tokyo. Courts martialed in the British system are adversarial, with prosecution and defence, but unlike common law courts, they don't have a judge or a jury. The verdict and sentence are determined by a panel of officers. A judge advocate is appointed, often, who is a lawyer, a trained lawyer, to advise on points of law. In M9, the military court comprised of 2 officers from Morotai Force and an RAAF squadron leader, because the victim was an airman. Of the 3, only the RAAF officer had formal legal training. The officers wore their campaign ribbons and medals. The defendant, Takeo Iwasa, was stripped of rank insignia. The defending officer was a lawyer from Wollongong who had no experience in military law, and he was given 3 days to prepare for the defence. There was a pool of 12 lawyers, half of at Morotai, half of those were barristers, and they would go on later after the war to become judges in the Australian system. So you had concentrated on this small island quite a pool of very fine legal minds. The Morotai trials were hampered by limited legal library resources, oppressive heat and humidity. The batmen of the officers were kept busy with the laundry because the officers would have to change their uniforms twice a day. The defence, the facts of the case were clear. They were not in dispute. It became a question of law, and the defence, all he had going for him was to try and claim alter vires, which means, to challenge the constitutional validity of the War Crimes Act and the validity of this court to try Takeo Iwasa. These were rejected. These were by the court, but after a bit of deliberation, in subsequent cases, the same arguments would be put forward by this defence counsel, but they would very quickly reject it and just take it down as noted. Iwasa had a signed statement saying that he had ordered the platoon leader to choose an enlisted man to perform the stabbing of the airman. He'd signed it, and he wasn't aware that that could incriminate him. This is where we get a bit of a relaxation of the evidence laws that was part of the, which is a controversial part of the War Crimes Act. The relaxation of the evidence law, what constitutes as evidence. So in a normal court of law, because he didn't know that this was to be used against, this could be used against him, it would be dismissed. But in these war crime trials, it was deemed to be authentic, and it was admitted as evidence. The court asked Iwasa to provide the defence. He declined, and after deliberating for 25 minutes, the court returned a verdict of guilty. In the War Crimes Act, the court's empowered to impose 4 penalties: death, either by hanging or shooting, imprisonment, a fine, or restitution for stolen or destroyed property. The last 2 were not used. There was an agreement amongst the Allies that they would not try small cases, that they'll only concentrate on the severe cases where it'd either be death or imprisonment. The court did condemn, came up the verdict of guilty and sentenced Iwasa to death by shooting, as well as 7 others. These subject to the confirming authority. So these verdicts, the court proceedings, would then go to the Judge Advocate General in Melbourne, where the headquarters for the Australian Military Forces was. He was a trained lawyer, a very high-standing lawyer. He would look at those, and he would advise the confirming authority, who was Lieutenant General Sturdy, the CNC in Melbourne. So it was General Sturdy's decision to either confirm or dismiss the guilty verdicts of the courts. This was actually quite typically with death sentences in the past in the civil area in Australia. It is the government in power, the executive, that makes the decision to confirm. Here, the Labor government had the CNC of the Australian Military Forces making the decision. It was a way of distancing the decisions, because the Labor government had an abolition platform, and had in the past, when the Labor government was in power, had mitigated death sentences to terms of imprisonment. But here they separated the powers. The Australian public just simply were not prepared to allow those condemned to have their sentences mitigated or commuted to prison terms. So it was very much a political decision to have the army make the decision. Under this Liberal government, the Labor government, 132 death sentences would be carried out of the 137 that would eventually be decided in Australian trials.
Wow. Yeah.
In M9, the defending counsel issued a petition to the Judge Advocate General against the verdict and against the severity of the sentence. He rejected it and Sturdy confirmed the sentence that Iwasa was to die by shooting. That's the first 9 trials to deal with that, with 8 sentenced to death. I'm going to go to a very different style of trial, and this is the murder and mistreatment of Australian prisoners of war at Tantui prison camp in Ambon. It's about a week, 10 days after Pearl Harbor, the Australians sent 1,000 soldiers from the 2nd 21st Battalion, what called Gull Force, to Ambon to support the Dutch. When the Japanese invaded Ambon, the Dutch and the Australians were rolled up in quick time, and the Dutch surrendered in February 1942, 1st of February, and the Australians a few days later. The captives in Ambon City, were confined to their barracks, but now as PWs. And in October 1942, there were 540 Australian and Dutch prisoners at Tantui camp. By the end of the war, only 139 Allied PWs survived, most of them in a pitiful state, as you can see in the pictures. So it was a death rate of 74%. 6 trials on Morotai concerned crimes committed by Japanese and Formosan troops against the Australian and Dutch prisoners of war in their custody at Tantui. They were along the lines of, we'll go to here, there were four areas for M45 that were charges. So the physical beatings and torture, compelling the sick and infirm prisoners of war to go out to working parties, and failing to ensure the proper provision of food and medical supplies. The big difference between this case and the case that I was referred to before is that the first case, the facts were clear, and you only had 1, 2, and at most 3 accused in each trial. Here, with M45, the whole garrison was gathered in one swoop. 80 men, 80 accused, were brought to, they started off in Ambon and then had to move to Morotai to continue the court. And it was for war crimes that had occurred over 3.5 years rather than one evening, like we had with M9 at Tal. The M45 started in Ambon on the 2nd of January, went to the 18th. The Dutch wanted to access their holding, their colonial holding of Ambon. So the whole court, the Australians had to move out and move the whole court to Morotai to continue. The man standing on the right is Captain John Williams, and he had to go to Ambon to search, to get information about the war crimes that were committed at Tantui. Now, he was working by himself. He was unassisted. The Australian prisoners who were liberated and taken to, they were liberated about a week after the end of the war and transported to Morotai, and were in hospital or just in the camp if they were well enough, but they were all in hospital. And Captain Williams had to go to each one and have a questionnaire filled out to try and list what war crimes were committed. And I'll give you, this is what the questionnaire looked like, at least in the front. It was only 3 pages. Sometimes affidavits were signed. So from Morotai, from their hospital beds or from their camp, They filled in these questionnaires. He was armed with 130 odd questionnaires, went to Ambon to try and identify the guards who had committed these crimes. There were no Australians with him. He did. There was a Dutch person, a Dutch soldier, who stayed in Ambon after the war because his wife was Ambonese, and there was one or two natives that tried to help out. But we have, in preparing the case for M45, all he really had were these questionnaires and these signed affidavits. By the time the court had started in early January, all the Australians from Tantui had been sent home, had been repatriated. So we had to have these questionnaires in court. It's quite difficult. There is the hearsay. So, someone told me that the Dutch over there were beaten up and things like that. But also, it was very difficult for the Australian soldiers because they didn't understand Japanese, and they didn't understand, in many cases, the names of the guards.
Yeah.
So they would give them nicknames like Horseface or Giggling Gertie or Doll or the Blob or the Mad Carpenter, etc. And the Mad Carpenter beat me with an iron bar and things like that. And so the only persons who could identify the guards, either collaboration with the commanding officer, the Japanese commanding officer, or it was the Dutch soldier, or the natives. And the Dutch soldier admitted that he didn't know most of these guards. So because the Dutch soldier was in a different camp, there was a Dutch camp and an Australian camp. So the court had to judge using this as evidence, where typically when you've got documentary evidence, you have the person who wrote it and put him under cross-examination for the defense. The defense does cross-examination. The court had to weigh up what this evidence was worth. In the end, and there was 80 of them, so it was a very protracted court. And there were 4 death sentences, ultimately, that were confirmed by both the judge advocate and the confirming authority. 34 prison terms, but what's amazing, there were 42 acquittals. So especially of the other ranks, of the petty officers and that type of thing.
And this is showing up like what we talked about with Greg Way on the trial of Carte Student, is that you've got crimes, you've got bodies, you've got people who know and saw things happening, but they just can't quite tally up who did what to whom sufficiently to reach a legal verdict. And this is the, as I keep saying in this is my fundamental learning from this. It's not that the Australians haven't got people here to do this. It's not like there isn't support for this process. It's not like they haven't invested time into trying to do this. It's just they're mired in this difficulty of actually making a legal case. And this is the, in a sense, the Allies are paying the price of being from a democratic country.
Yes. Well,
is that the Axis just wouldn't have bothered. If they think someone's guilty, they just take them out and shoot them. They don't have the difficulty of having to build a case. And the Allies are trying hard to be whiter than white. They're dealing with the fact you said there's a revenge element of the Australian public. So they're trying to do this the right way, but it ends up meaning that it all becomes a bit woolly.
Yeah, and also, I mean, you've got the victims, the surviving victims back in Australia. That we simply did not have the shipping or the logistics or the cost, or be able to meet the cost to have them move, to come and be at the Morotai trials. So it's a whereas it was quite different of course, for the international military trials in Nuremberg and Tokyo. So the summary of the Morotai trials. There were 25 trials, 129 defendants, in which 7 were indicted in 2 trials. There were 55 acquittals, 56 prison sentences from 1 to 20 years, and 25 confirmed death by shooting. Actually, 3 of them were received 2 death sentences. So therefore, there were 22 war criminals to be shot. I want to talk a little bit about the executions and how this impacted. These would be the first ever executions by the Australian military. Never done it before. Back home, the Australian public, the Return Service League, the press, politicians, they wanted to see these executions. They were demanding them. These court cases had gone on too long. They wanted to see some justice happening. However, those who were actually on the island, many of them had quite different views, had very different emotions. On the left-hand side, there's a sketch of Captain Iwasa by Alex King, who used to be, who was in signals on Morotai, and he used to be the artist from the Daily Telegraph, from the newspaper. He had a 50-year career. But this sketch is signed by both Iwasa and by King. There was a certain rapport developed with the condemned man. On the right, there's a newspaper article. Evidently, okay, so the night before the executions, the condemned men, there was laughter, there was joking, there was food. Iwasa himself took out his bamboo flute and played. The Australian nurses started dancing the jitterbug to his playing. So it was a lively tune. They're dancing the jitterbug. Tomorrow, he dies. That sketch, the cartoon, I can't find it. I don't think it survived. They weren't allowed to take a copy of it. So what we have on the right is so you have on the right the Australian nurses with their Owen guns, a terrific Australian submachine gun, shooting Iwasa, and he's saying, "Don't forget the shooting." Is the caption. It's a very, the fraternization at the camp was something that, of course, the authorities didn't want to get home. Sorry, I'll go back to here. I want to stay on that. How firing squads are run. Well, once the decision was taken to carry out the death sentences, the presence of part of the Morotai force that was still there ensured that enough men were available to form firing squads. Now, the problem is, for Australia, we've never carried out a firing squad. And we had to go, of course, to the British, who are experts at this sort of thing. And so using the British standing orders on military executions was deemed to be the most humane. And so instructions were sent from Melbourne in the end of February on how to conduct a firing squad. The first firing squad in the history of the Australian military took place on the dawn on the 6th of March 1946 at a secluded beach lined with coconut palms, not far from the prisoner of war compound. 13 convicted war criminals were shot in 4 batches, with others to follow later in the month. 20 seasoned soldiers were chosen and given the chance to decline on conscientious grounds. And because of the large number of executions, the standard detail of 10 riflemen per prisoner was reduced to 5. At first light, the Provost Marshal assembled his men. Their rifles were loaded and wrapped. 2 were covertly charged with blanks so that no soldier would know for certain he had fired a fatal round. That practice had come from the days of musketry, but with modern weapons, the difference in recoil could likely be felt.
Yeah, you'd know. You'd know.
Sorry?
You would know. A blank round for a rifle is totally
Yeah.
different to a live round.
Yeah.
But anyway.
But it's amazing what the mind does, right?
Yeah, you'd convince yourself you hadn't felt it. Yeah, maybe. Yeah, yeah.
At 7:30 a.m., the first group of condemned were brought out. As they were strapped to their chairs, they chatted, laughed, and sang. Some of them thanked the Australian Guards for their kindness. It's a very interesting thing. They were told to put on black hoods. They refused, but they only agreed after the provost marshal request. It's to ease the conscience of the firing squad.
Yeah,
and they agreed to do that. White discs were pinned to their chests as targets, and the firing squad, which had spent the last couple of days practicing, took positions 15 yards away. The condemned shouted "Bonsai" 3 times, and the provost marshal gave the order to fire. Not shouted, because he didn't want to startle the condemned, but just loud enough for the firing squad. A medical officer, stepped forward with a stethoscope to confirm the death. A rumour exists that a coup de grace had to be given to one of the condemned by the provost marshal. Iwasa himself was shot in the second batch. After each execution, a Japanese burial party approached, bowed reverently before the body, and carried it away. The Morotai war crimes trials drew to an early close. By the end of February 1946, 25 war crime trials involving 129 defendants had been conducted on Morotai. By this time, the 34th Battalion had been deployed to Japan, so that's gone. And most of the Morotai force were repatriated or demobbed to Australia, leaving too few men around to maintain the prison compound, the kitchens, administration, officers' mess. At the same time, the Dutch were pressing to reassert control of the island before Indonesian nationalists could take hold. And so the trials were hurried to a close. Those who are serving sentences, on Morotai, only had the time to execute 11 of the 22 criminals that were tried on Morotai. The other 11 had to be transferred over to Rabaul for the shooting, for the executions. But there were several serving prison sentences. They were also transferred to Rabaul in the big prison camp to continue serving their sentences. And I think I will call it quit there, if you like, Paul, and happy to answer questions.
Yeah, well, brilliant stuff, David. And I think what I'm thinking about is the fact that we know that the trials of the Nazis were affected by the fact the Cold War is beginning to bubble away, and there's dealings to be had with the Soviets, etc., etc., etc. And I don't think I kind of realized that the Far East has that same issue. There's the Dutch interests in their empire. There's the fact, as you said earlier, that Japan is going to be occupied by the US, etc. So all these factors are running in parallel to this seeking of justice. And as each month passes after the end of the war, I think the vitriol amongst the public for revenge kind of lessens a bit, because once your sons and your husbands have returned home, once you've kind of buried your dead, and in Britain there's a new government and things like that, I think people start looking forwards rather than backwards. But as you said at the beginning, David, your interest is in the cost of cultural history.
Yeah.
With 80 plus years of historiography, looking back at how Australia managed its war crimes trials, I mean, what kind of score would you give your country for dealing with it? I mean, the intent is clearly there to be balanced, objective, and within the framework of law. But what's your feeling about the whole thing?
I think the prosecutors, the courts, the defenders did their best within the parameters of the War Crimes Act, and there was a sense that the judge advocate in trials would bias towards the defendants in explaining the law and all that, and to help their lawyers. In the last trials, had Japanese lawyers defending their countrymen, and the judge advocate would take the time to explain the rules of evidence and how court procedure worked. So I think within the trials themselves, there was generally a sense of being fair, and to be seen to be fair. On the other hand, and when we get to the Judge Advocate General down in Melbourne, who receives the petitions and counsels the CNC, the confirming officer, he is, well, there are a few of them, but they tend to be very fair and say that I cannot see how this should be confirmed. So they're very clear where a verdict does not seem to stand up to what's in the court proceedings. However, and I'll probably be shot for this, but I think that the confirming officer erred on the side of almost like a political reason to have the executions done. So that I think ultimately there were some who ought not to have been executed.
Right.
But overall, but on the other, so only very few cases do I remember the confirming authority reversing this decision made by a court.
And it's interesting. I mean, people are saying to make sure I thank you for giving a presentation on such a complicated subject. I mean, clearly, as with the Third Reich, only a very small percentage of people responsible for crimes were ever brought to justice. So I think the world is sort of expecting or understanding that some of the people who are on trial are kind of representing those who can't be put on trial. But that doesn't make it good for you as a defendant if you're there for someone else's crimes. And then balanced with that is the fact that the Allies are aware that the crimes will be being talked about for decades and centuries. We're still talking about the Holocaust, of course. But therefore, the legal procedure to deal with that will also be studied forever as well. This isn't some, I don't know, local case for murder in some small town in Australia that everybody will forget about 20 years later. This is the world spotlight is on what's happening here in Morotai, what's happening in Norway, what's happening in the other countries they're looking at. So I think it's balancing trying to be seen to do the right thing, but also trying to bring some people to justice so that it feels that there has been a point in the victory. It's very complicated.
Yeah. I think we're appeasing the wounds of those who are impacted in Australia, because Australia had 22,000 prisoners of war of the Japanese, of which 8,000 died. So they were raw, and also we're very close to Japan, so we don't want it to happen again.
It's all about that balance. I mean, the fact that you're part of the world now. Without your trade to Japan, without your trade to Taiwan, you wouldn't be at the world player you are. So we all have to get on with each other to some extent 80 years later. So Australia has a duty of care to the families of those who didn't make it back because of Japanese cruelty and atrocities, but it has a duty of care to follow a legal precedent. It's also got to make its way alongside the US, that is a much bigger player in 1945 in this part of the world because of its size, because of its. So it's a. I don't admire Australia. I don't. What I'm trying to say, the respect for Australia trying to balance all those things in 1945, 46. Whatever they did, they've ended up being criticized on some levels for being too lenient, not lenient enough. It's complicated.
Well, in 1953, Australia allowed the remaining prisoners the remaining war criminals to be repatriated to Japan and to go to Sugamo prison under the Japanese control. But what really prompted that was the trade. We wanted a longer trade, a bigger trade issue with Japan. So it was a political, economic decision.
Well, one thing we've learned on this channel is that politics, geopolitical situation, the war, public opinion, historiography, it all connects, and these lines intersect. And I'm still basically proud of the fact that I was involved in. The Allies are trying to do things the right way. I think everything has been, the fact that they're trying to explain to the Japanese defendants, here's the procedures we're doing. This is a military court. These are because they weren't doing that for the Australians. They weren't doing that to American pilots. They were beheading another. They would. You were just, if you were an Allied pilot in that situation, you were swept along in a situation you didn't understand. At the very least, there's an attempt by these courts to explain to the Japanese defendants, here is the situation you're in, and the fact that these Japanese are developing some kind of affection for the people who are guarding them says a lot. I think. I don't know. It's complicated. I don't quite know what it's saying, but it's saying
human nature versus
it's trying to be decent. I think that's the thing. There is a flaw. There are flaws in the legal system, but there's an attempt at decency, which I think is definitely there. And this is a comment that would sum things up. And my mother had an uncle who died in 1943 in the Burma Railway. She still hated the Japanese in the 2000s, refused to eat in the Japanese restaurants in that area. That's how they felt. Well, that's something that I think. I grew up, as a teenager. I was a member of the Far Eastern Prisoners of War Association as associate member, and I went there and heard these harrowing tales told by these British guys of what they experienced. And they weren't exactly affectionate towards their former enemies, and it's understandable. It's just interesting. But David, it's been fantastic talking to you. Been a brilliant presentation. We're back in a few hours time, folks. James Fenelon is looking at the Japanese paratroopers in World War II, so we're going to look at them from being defendants to the military side of things, which is just interesting. David, you're welcome to come back whenever you want. The link to David's website is in the description below, where you can look at what he's been doing in terms of his writing and projects. That'll be really good. And thanks for everybody for your fantastic comments. I will see you all in a few hours time. Cheers, everybody. Bye.
Thank you.